Now, my lord, please see para 104. It is pertinent to note that nowhere in the substantive part of Article 200, the term as soon as possible has been used. So this is again on the time, but when we are on Article 200, as soon as possible is proviso when he returns the bill. It was there earlier with time limit in the pre-constitution regime, which was taken away. It is pertinent to note that nowhere in the subsequent part of Article 200, the term as soon as possible has been used, which means that the Constitution did not intend to put any sense of time limit during the exercise of first three options. Moreover, the governor under substantive part of Article 200 can simply sit or withhold assent to a bill if he believes that the bill is unconstitutional and beyond any remedial changes, in which case the bill shall fall through or lapse, as has been observed in several decisions of this honorable court, referred hereunder. The framers of the Constitution consciously avoided putting any timeline for exercise of powers either under Article 200 and 201, which is evident from the fact. Well, this is again on the question of timeline, but let me complete this, my lord, so that also assists your lord. The time limit prescribed as shown in the history was consciously dropped in Article 111 and was replaced by the expression as soon as possible. And B, the very next Article 201 in its proviso stipulates the time limit for 6 months. Now, my lord, I have given dictionary meaning of the term withhold lapse. The point I'm making is not what happens to the bill. The point I'm trying to make is that whenever time is stipulated, it is provided for. You cannot read into it. It amounts to amendment of the Constitution. That's, my lord, a separate point, my lord. That I'll come to that. My lord, now, what is the dictionary meaning of the term withhold? This is not considered by, my lord, the debate in Constituent Assembly debates, as your lordship said, asked me. My lord, 106. My lord, as per the New International Dictionary, withhold means to hold back, keep from action, to desist or refrain from granting, giving or allowing, keeping one possession or control. Refusing is also a part of the term withhold. Refrain from granting is also. Then return means to go back or come back again, to pass back to an earlier passover. Then, my lord, Black's Law Dictionary says withhold means to retain in one's possession that which belongs to or is claimed by another, and return means to bring, carry, or send back, the place in the custody, to place in the custody of, to restore, to redeliver, to send back. Now, my lords, kindly come to 108. It is of utmost relevance to note that the constitutional requirement of expediency or a sense of urgency is incumbent upon the governor only when he decides to return the bill to the state legislature for reconsideration. This is evident from the expression, which I'll come to little later, my lords. My lord, please now come to my lord, directly, my lord, the judgment. I'll just, my lord, please come to page 164. My lord, page 168. Then I'll take your lordship, my lord, to the potential acts which are, my lord, there are possible acts under the state list within the legislative competence of the state legislature, but cannot be assented to. There is no question of referring to the president, and returning is out of question, because even if I return it as a governor, and if it comes back, then I have no power of withholding. So I'll have to use that discretion on the first occasion. I have given the examples. I'll come to little later. Well, okay, kindly, my lord, have a look at page 166. Some examples, my lord. Where, what would the governor do? My lord, he is not just a postman. He represents the Union of India, appointed by the president. President is elected by the entire nation by way of an indirect election. And that is also a way of democratic expression, my lord. An individual who is not directly elected is no lesser than the individual who is indirectly elected. And again, the president acts as per aid and advice of Council of Ministers. And Council of Ministers are responsible to the entire parliament. This is the framework, my lord. This is the check and balance, my lord, which is there. Please come to page 166.
Yes.
My lord, Chief. 166. My lord, these are the examples, my lord. A legislative session bill fixes only 2 sitting days per year. It is presented before the governor. Lord, then a confidence motion bill requiring 2/3 supermajority to test the council's confidence, directly contrary to the constitution, etc., etc. Now, my lord, kindly come to page 168, the case law. My lord, before I read the case law, my lord, the 2-judge bench in Tamil Nadu, forget the facts, I repeatedly say, my lord, the 2-judge bench in Tamil Nadu relies upon a 3-judge bench in state of Punjab versus Union of India. State of Punjab takes the view that the word withhold will have to be read with first proviso, that you withhold and return, which in my submission is erroneous on textual interpretation and is in ignorance of several 5-judge bench judgments exactly on the point. And those judgments, my lord, now I place for your lordship's consideration. My lord, on this withholding, my lord, let me say something, my lord. I have one distinct advantage. And therefore, my lord, what I am saying is really on the interpretation of the constitution. Why I say I have a distinct advantage? I had been a law officer of a state where state government was of a different political dispensation, central government was of a separate political dispensation. Today, it is a reverse situation. It was a reverse situation. Today also, it's today.
You would have been that side and you would have been this side.
Yes. So I know, my lord, so my lord, functionally, how, my lord, it functions. My lord, I'm aware of it. So it's not, my lord, my attempt to protect the power of the governor anyhow. But, Lord, I must, my lord, request your lordships that these are all plenary constitutional powers vested upon high constitutional functionaries. A possibility of misuse or abuse may perhaps not guide your lordship's interpretation. Lord, for example, Lord, time and again your lordships, while sitting in the Supreme Court or on the division bench, have said that this was an abuse of writ jurisdiction. But then the problem is not with the writ jurisdiction. If we examine the contours of writ jurisdiction, it will have to be examined that it would be used for the purpose it is conferred upon the Constitution. Lord, now before I take your lordships to the judgments, may I request your lordships to read 20, 200 and 201, the way I like to read. And I am reading it as a student of law, the way it is to be construed. If there is a power of withhold, as I understand, Lord, let us not give any interpretation which kills the power. Whoever is the governor, whichever is the party in power in state, center, doesn't really matter. But kindly have a look at, my lord, even at the cost of repetition, my lord, 150, my lord. Please have a look at it, my lords. And then, my lord, I'll immediately come to the judgments. When my lord, page 150. When a bill has been passed by legislative assembly of the state or the council, it shall be presented to the governor and the governor shall declare. Either, my lord, would mean a choice. Either that he assents to the bill or, my lord, this is the second option, he withholds assent therefrom. So I'm withholding the assent of the bill. What is the meaning of withhold? I'll come to. Or that he reserves the bill for consideration of the president. He will have one of these three. Provided that the governor may, here it's not shall. Fourth option is given. As soon as possible after presentation of him to the bill for assent, return the bill if it is not a money bill, together with a message requesting that the house or houses will reconsider the bill or any specified provisions thereof, and in particular will consider the desirability of introducing any such amendment as he may recommend in this message. And when a bill is so returned, the House or Houses shall reconsider the bill accordingly. And if the bill is passed again by the House or Houses with or without amendment and presented to the Governor for assent, please mark, the Governor shall not withhold assent therefrom. Note how I give the meaning of the term withhold used in the proviso, that you will not kill it thereafter. Both words are used in the same provision and has the same meaning. Correct, my lord? Now, going it a little further, my lord, suppose he reserves it for the president. Then 201 comes into play. Please have a look, my lord. When a bill is reserved by the governor for the consideration of the president shall declare either that he assents to the bill or that he withholds assent therefrom. My lord, we take it that withhold means temporarily withholding. Then please see, my lord, the distinction in the proviso. Provided that where the bill is not a money bill, the president may direct the governor to so and so, so and so, so and so within 6 months of the date of receipt of such message, and if it is again passed by the House or the Houses with or without amendment, it shall be presented again to the president. Because there is nothing, then it stands withheld. Because there is nothing above the president. That does not, it neither says, then the governor, president shall assent to the bill. So, my lord, both the provisions in the same document, namely the Constitution, word withhold used at two places in Article 201, Lord, leads in my submission to only one conclusion, that withhold means in rarest of rare cases. But that, no, sorry, this cannot be done. And I have given instances. For example, and without, my lord, giving any real instances, central passes a law and some state legislature passes, central means parliament passes the law, and some state passes a law based upon whatever considerations, that this law will not apply in my state, and the bill is presented before the governor. Can he assent? Answer is no. Can he refer it to the president? Answer is no, because it's palpably wrong. He can't return it because then he will be losing his right to withhold. Then, my lord, withhold is only in rarest of rare cases, in, my lord, exceptional circumstances, and therefore I said that where his existence as a constitutional functionary and his oath of office of defending the Constitution requires him that I will have to withhold, because he is the only person apart from the president who takes oath of defending the Constitution. Unless, my lord, this is read, the governor's office will merely become a post office. He can either assent or withhold it and send it back to the House. And if the House says no, nothing doing, we go ahead, then he cannot withhold. Or as a postman, he will send it to the president. I don't think, my lord, the president's position is envisaged in the Constitution as a postman. He has, my lord, a wisdom. And in real life, my lord, how things work out, I can tell your lordships, my lord. Lord, as a matter of fact, every matter doesn't come to your lordships. Lord, governors are also seasoned people. Political leaders are also seasoned people, irrespective of the party they represent. They have, Lord, years of political experience, public service, my lord, to their credit. What happens is, my lord, whenever a bill is presented, Lord, generally the governor calls the chief minister and says that these two provisions are doubtful. And I would have very serious reservations. If it is repugnant, I'll have to refer it to the president. Sometimes, my lord, the chief minister also agree that, all right, we also don't labor much on this. I can promise you, you return it to the House, we'll get it sorted out. And the matters are sorted out. Lord, every problem which may arise under the functioning of the Constitution may not have an answer or a solution in legal proceedings. Lord, when the matter is referred, when the bill is referred to the President of India, there is a procedure stipulated under the office memorandum. Lord, it goes to the President's house. The President's house narrates what are the repugnancies, which provision is repugnant, how it is repugnant, whether it is repugnant. Thereafter, it is sent to the Ministry of Law as well as ministry which is concerned ministry, which is called the nodal ministry. If it's education, it goes to education ministry. Agriculture, it goes to agricultural ministry. Then their feedback is received. That all right, there is some repugnancy, but both can coexist. It will, because why there is a requirement of presidential assent in some cases, that the bill of the state legislature should not be in conflict with the national policy formulated by the parliament. And therefore, that is the ground on which the nodal agency says that though there is a deviation in the state law, it is in fact not affecting the national policy. It is a state specific provision, though repugnant to the central law. Then the president gives the assent. And otherwise, my lord, if in some cases, my lord, the president returns the bill, and if the bill is, my lord, again passed, it comes back to the president, and then it dies, it lapses. Because Article 201 proviso does not stipulate any my lord, consequence. My lord, if we were to accept, my lord, if your lordships were to accept the term withhold in the main provision of Article 200 to mean temporarily temporarily decide not to grant assent immediately. Look, kindly see, this is third angle. Lord, suppose the main part of 200 would have contemplated that withhold means kind of suspension of my powers, that I'll not withhold. And as state of Punjab judgment says, I will refer it to the House. Then the word used would have been, if the House returns, the president shall grant assent. But it says it will thereafter not withhold. Means your right to withhold ends if you do not exercise the first time. Otherwise, my lord, the only meaning, my lord, which we can give, if, my lord, the interpretation given by Tamil Nadu is right, that proviso last part says that if the bill is returned back by the House after reconsideration, he will grant assent, which is not there. He will not withhold it. That is, my lord, the answer. Now, please come to the judgments, my lord. Page 168, my lord. The first judgment is Kameshwar Singh. Start with the judgment, page 168. But, my lord, power being plenary in nature, it has to be left to his constitutional discretion, my lord, whether it is a case exceptional, not exceptional, my lord, that he will have to decide, my lord. That's the way, my lord, constitutional functionaries, powers, functions, responsibilities, limitations, they are, my lord, interpreted. That's my respect. About which the court would have minimum knowledge, my lord.
So,
Possibly.
can
No, the Constitution is a living document. No, it was a cow and calf, my lord. That happens, my lord, in court also, but I'll come to that. There is one judgment, my lord, that therefore I say that inability for good reasons, bad reasons of one organ to do what is expected would not empower another organ to take over. Lord, I'll come to that, my lord, because no, Mr. Sen was right, and he could say that because he was in parliament with, my lord, the privileges attached to it, my lord. But your lordships would also be, my lord, aware, and your lordships are aware, that the speaker under the tension, therefore,
and do
that's the
decision.
point, my lord. He is a
And
tribunal.
the-
He is a tribunal. My lord, your lordships fixed the time limit, and rightly, in case of 10 schedule, because speaker, right from Quixote Holohan, he is held to be a tribunal. He is not exercising, my lord, any
Tribunal,
plenary. So, my lord, let me come to, my lord, page 168. I'll come to that judgment, my lord. That is one of the judgments relied upon by the other side. And therefore, I'm going to say that. Lord, as a matter of fact, and it would be interesting, I'll go in detail when I reach that stage. Lord, the parliament, my lord, amended the law that because judiciary is unable to do within a particular time limit, no, I'm on a different judgment. But I'll read that. Symbol matter, my lords. The cow was, my lord, quite auspicious for them.
That's right.
We will not go into those issues.
Let's not. And in any case, I am asking a wrong person, my lord, now. My lord, page 168. Please have a look, my lord. This. 168. My lord, the judgment. This is a 5-judge bench judgment. State of Bihar versus Kameshwar Singh. My lord, for two purposes I am relying upon. A, the governor is a part of the legislature and whatever function he exercises is quasi-legislative. The power of assent is quasi-legislative. And there are judgments on that, my lord, point. My lord, please come to, my lord, page 169. It's, my lord, my learned friend is right. It's legislative. Lord, 198, I have just highlighted. I am not right now saying this, my lord. I'll come to separately. The legislature of Madhya Pradesh consists of governor and the legislative assembly, but relevant is 235 at page 170.
Where you read this? Sorry.
I'm sorry, my lord. Page 168, the judgment starts. It's state of Bihar versus Kameshwar Singh.
Para 198.
Okay, you quoted in the para. Okay.
Yes, but it's quoted, my lord. It is
For a judge.
constitution bench.
Highlighted.
It's a 5-judge bench judgment. My lord, kindly see at 169. My lord, I'm at the foot. My lord, please come to page 168, para 20. Mr. Somaya's argument. Your lordship gets me? My lords get me.
This.
Mr. Somaya's argument based on clause 3 of article 31.
You are
which
at page,
ref-
page
Page
168 bottom.
168
Bottom.
at the foot, my lord. State of Bihar versus Kameshwar Singh, para 20. Mr. Somaya's argument based on clause 3 of article 31, to which reference has been made earlier, is equally untenable. It is true that the legislature of the state includes the governor and that a bill passed by such legislature cannot become a law until, please mark, until it receives the governor's assent. Article 200, however, contemplates one of the 3 courses being adopted by the governor when a bill is presented to him after it is passed by the House or Houses of Legislature. 1, to give his assent, or to withhold assent, or 3, to reserve the bill for consideration of the President. Correct, my lords? The first proviso to that article deals with a situation where the governor is bound to give his assent and has no relevance here. The second proviso makes reservation compulsory, where the bill would, if it became law, derogate from the powers of the High Court, but such reservation, it is important to note, should be made without the governor himself having assent to the bill, giving assent to the bill. It is significant that the article does not contemplate the governor giving his assent, and thereafter, when the bill has become a full-fledged law, reserving it for the consideration of the President. Indeed, the governor is prohibited from giving his assent where such reservation by him is made compulsory. The Constitution would thus seem to contemplate only bills passed by the House, etc. Please come to 235 at page 170. Great.
How do you, the first proviso to that article deals with the situation where the governor is bound to give his assent.
If it returns, if it is returned, that's what they say. Obviously, my lord, he cannot withhold. Then he has to, my lord, he can withhold, or my lord, he can give assent, or he can even still refer. He can still refer. He may give an opportunity to the legislature. No, my lord, I'm sorry, my lord. I'll again, my lord, make myself clear. He has 3 options in the main proviso. He can grant assent straight away. He can withhold, which according to me, the bill lapses or bill falls through, as Supreme Court says. And third option, refer it to the President. Fourth option, other than these 3, is when he feels that there is some repugnancy somewhere, or there is some tweaking required somewhere, then with his message, he will send it, he will return it to the House with a request to reconsider it. When the House reconsiders it, then the embargo is he cannot withhold. But he can still say that, all right, you have not considered my suggestion, you have not removed the repugnancy or whatever difficulty I have suggested. I now refer the matter to the president for his assent. That is not prohibited. Correct, Mullah? Now please come to 235. Great stress is laid on the words law and the legislature of a state. It is stated that the clause postulates a law made by the legislature of a state. Reference is then made to Article 168, which provides that for every state there shall be a legislature which shall consist of the governor, and so far as Madhya Pradesh is concerned, of one house, that is Legislative Assembly. The argument is that Article 31(3) requires that a law must be reserved for the consideration of the President. If a bill passed by the Assembly is reserved by the governor for consideration of the President, without giving his own assent thereto, it cannot be said that a law is reserved for consideration of the President, for up to that state the bill remains a bill and has not been passed into law. Therefore, it is urged that after a bill is passed by the State Assembly, the governor must assent to it so that the bill became law, and then that law to have effect must be reserved for consideration of the President. This admittedly not having been done, the provisions of Article 31(3) cannot be said to have been complied with, and therefore the Act cannot have any effect at all. I am unable to accept this line of reasoning. For one thing, it assumes that a bill passed by the State Assembly can become a law only by the assent of the governor. That is not so. Now please see. The procedure to be followed after a bill is passed by the State Assembly is laid down in Article 200. Under that article, the governor can do one of three things, namely, he may declare that he assents to it, in which case the bill becomes a law, or he may declare that he withholds assent therefrom, in which case the bill falls through. So, if he does not choose, my lord, the option of proviso, the bill falls through. So, unless means that's the option. Either I withhold or I revert, I return the bill. Otherwise it has no meaning. Falls through has no meaning. Therefore, unless is an exception, that if he withholds at the first instance, it falls through. Unless he resorts to the proviso, unless the procedure indicated in the proviso is followed, or he may declare that he reserves the bill for the consideration of the Parliament, in which case the President will adopt the procedure laid down in Article 201. Under that article, the President shall declare either that he assents to the bill, in which case the bill will become law, or that he withholds assent therefrom, in which case the bill falls through, unless the procedure indicated in the proviso is followed. So falls through has only one meaning, because it's an option given.
The fourth option.
So, my lord, what it says is, I'll put it, my lord, I rephrase myself. My lord, unless he exercises the fourth option.
Correct. Option 4.
Correct, my lord. Therefore, I am saying that he has to assent, withhold, or reserve, unless he chooses the fourth option. Otherwise, one of the three options are complete in themselves. So, therefore, my lord, my submission is that the proviso is an exception to first, second, and third in the main part. He may not grant assent, he can return it. He may not withhold, he may return it. He may not reserve it for President, he may return it. But after returning, if it is passed, one option is taken away, he can either assent or first option. No, he cannot thereafter. Unless is the word used in the judgment. It's not in the article.
Unless.
Meaning thereby,
Beforehand.
meaning thereby, he can assent or follow the proviso. He can withhold or follow the proviso. He can reserve it for the President or follow the proviso. But if he withholds, there is no question of following the proviso. That is why it says, the proviso says, then you cannot withhold, because then you have abandoned your right of withholding at the cannot.
That's what you're saying.
Yes. That out of three, he says,
You're saying.
I'll not, yes. Out of
But
three.
you are
No,
scary
I'm
part
not
of
saying
that.
there is
That's
no
why,
judicial
that's
right.
why the difficult part.
I'm sorry. I am saying it's not justiciable, and Supreme Court has said.
Same thing.
My lord, your lordships are, my lord, I am yet to argue on judicial review and justiciability. My lord, there are several powers under the Constitution where we are not, my lord, for example, President also, my lord, other option of returning, yes. Then he can, he can,
Power under two yoga.
in a fact situation, my lord, suppose he withholds. Yes, exactly.
Not like a.
It's quite possible that the chief minister may go and say that please don't withhold
that the
entire, suppose, my lord, take an example, entire act is in list one.
But still it can.
There is no question of returning it. Kindly see.
Say.
So, my lord, it's not a statute, it's paraphrasing. Let's read it as a judgment. Yes.
It's a
No, it's a judgment. That's all. Difficulty is, my lord, the Supreme Court here is paraphrasing 200 and we are reading instead of 200. No, it unless is a separate option. Textually also it is a separate option. Kindly give otherwise, in which case the bill falls through has no meaning. Number one. Number two, my lord, suppose. Correct. Certain
Then it will fall through.
correct. But possible, kindly appreciate, but that depends upon the facts. My lord, suppose a state legislature were to pass a law. Correct. Your lordships are also in the 5
Yes.
I'm not on that, my lord. My lord, please appreciate, my lord, to take example of a state, my lord, where the legislative assembly, for good reason, because of the, my lord, feelings in the state, passes a law that we will not enter into any trade or commerce with a particular foreign country. The trade or business is in the second schedule. There is no question of, my lord, repugnancy, but it ultimately, my lord, is the subject of external affairs, my lord, with the country. The president may say that, no, you can't do this. There are several examples, my lord, which we can give, where something is so abnormal that president will have to say that withhold, I can't, my lord, suppose a bill is passed, my lord, regarding defense of the country. My lord, he will have to withhold. He can't return it to the house because his decision to withhold is based on the premise that you did not have the competence to do this. So then, my lord, Raja, my lord, Bhairendra Narayan
In
Bhup,
any case,
no, 200 is, my lord, examined. 200 is examined. This is precisely, that was the question which fell for consideration and it is, my lord, if we want to find out a distinction, there can be other distinctions. I bow down, my lord, to that proposition. There cannot be any difficulty, my lord. My lord, Raja Bhairavendra Bhup, my lord, was under the Government of India Act, but the same words I have already pointed out to your lordships, my lord, are used. Please see. Dealt with the constitutional validity of Assam State Acquisition of Zamindari Act and whether it was within the competence of the state legislature in the peculiar facts, etc. My lord, please turn the page over. Broadly speaking, it may be said that a bill begins to pend with its introduction in the legislative chamber and it ceases to pend, A, when it lapses under section 73(4), B, when the governor declares that he assents in his majesty's name to the bill, in which case the bill ripens into an act, or C, when the governor declares that he withholds his assent therefrom, in which case the bill falls through, or when being reserved by the governor for the consideration of the governor general, the governor general acting under section 76 declare that he assents in his majesty's name to the bill, in which case also the bill becomes an act, or when having been so reserved by the governor general declares that he withholds his assent therefrom, in which case again the bill falls through. F, when the bill having been reserved by the Governor General for the signification of his Majesty's pleasure thereon, under section 76(1), the Governor, under section 76(2), makes known by public notification that his Majesty has assented thereto, in which case again the bill becomes an act, and lastly, when no such notification is issued by the Governor within 12 months from the date on which it was presented, in which event also the bill comes to an end. My lord, because there was a time limit, otherwise it would lapse. In short, a bill may be said to be pending as long as it does not lapse or it does not become an act by receiving the assent by the appropriate authority or is not terminated by withholding of asset by such authority. Withholding has been given this meaning and this meaning only. It's a complete event, my lord. Once the governor says, I withhold, lord, if that is not a wise thing, then it is for the parliament to amend. But this is how judicially it has been interpreted. The contention of the appellant is that when the bill under yes, but now please see my lord, page 173, Purushottam Nambudri. My lord, again a 5-judge bench judgment. My lord, what I read was also a 5-judge bench judgment.
Yes.
Then Valluri, Basavaiya Chaudhary, my lord, I have, my lord, cited at 2 places, but I'll read it at page 173. One was cited to say that it is a legislative act. Grant of assent is a legislative act. And therefore, my lord, I would, my lord, come to that submission that there is no principles of natural justice or reasons, etc. It's a legislative act. It's a plenary constitutional power to be exercised by a high constitutional authority whose my lord, wisdom or bona fides are not to be doubted. Lord, please see at the foot, my lord, 173,